When fortunes collide with courtrooms, wealth managers, financial advisors, accountants, fiduciaries, and lawyers need real answers. Welcome to Wealth Litigated, where Professor Kelly Lise Murray, JD, lawyer, legal scholar, and retired Vanderbilt Law faculty, analyzes actual courtroom wins and losses in asset protection to deliver actionable insights that optimize your client's wealth outcomes. From explosive family feuds over fortunes to sophisticated financial fraud, each week we explore what worked to protect wealth and what exactly went wrong, so you get it right. And now, here's your host, Professor Kelly Lise Murray.
Welcome to Wealth Litigated, delivering all the drama of true crime without the blood. We don't just tell you what actually happened in court. We also show you why it matters to your professional practice and how it impacts your clients' wealth outcomes. Let's gavel in. How Bunny Mellon's grandson bet his fortune on Fidelity. In the Lloyd case, the husband's inherited wealth and marital infidelity led to a high-stakes legal battle over a $7 million adultery penalty. The Lloyd case is a Supreme Court of Maryland opinion from August of 2023. The divorce actually had 3 courts in total: the Divorce Trial Court, the Intermediate Appellate Court in Maryland, and then ultimately the Supreme Court of Maryland. The Lloyd case itself also spent some time analyzing 2 additional cases critical to the holding, and we'll be looking at them also. That's the McGeehan case from Maryland, 2017, and the Lloyd case from Pennsylvania, 1993. So who was Bunny Mellon? She lived an extraordinary life and died at the age of 103 in 2014, which is also a material fact in this case. But Bunny Mellon was from a pharmaceutical family. Her grandfather, her father. She had 2 marriages. Her first marriage, she had 2 children, including a son who was the father of the husband in the Lloyd case. Her second husband was Paul Mellon of the Mellon banking fortune. She was a philanthropist, a self-trained botanist. She knew art and architecture. She was a colleague and friend of Jackie Kennedy. Bunny Mellon designed the Rose Garden for Jackie Kennedy when JFK was president. Bunny Mellon and her second husband, Paul Mellon, bred thoroughbreds, and in 1993, their horse won the Kentucky Derby. At the end of her extraordinary life, she bequeathed a lot of her ultra net worth to charitable causes, but she also had an inheritance set up for her grandson, who was the husband in the Lloyd case. The husband in this case was a wealth manager by profession, degree from Georgetown in financial planning. The wife in this case was a successful caterer, and in 2017, another material year in this case, she was appointed to the White House as the social secretary. The central legal issue in this case is whether the $7 million adultery provision was valid and enforceable. The husband argued no, for obvious reasons. He argued it was excessive liquidated damages, that it created an unenforceable penalty, and that it was contrary to the public policy of Maryland. The wife responded that it was freely negotiated, and each spouse had 2 lawyers when they negotiated what was a postnuptial agreement that included the $7 million adultery penalty. The wife also argued that it was not liquidated damages, that it was enforcing fidelity and behavior, and that even though it was a penalty, it was enforceable. In Section 1, we're going to look at the facts and the postnuptial negotiations. In Section 2, we'll look at the procedural history, what the 2 lower courts ruled on this case. In Section 3, we'll cover what the Maryland Supreme Court analyzed and ultimately ruled. And in Section 4, we'll look at the wealth management takeaways. We have 2 timelines. This is the first. We're starting with the marriage in 2006. By 2010, they had 2 young children, and in 2010, Bunny Mellon gifted $1 million to her adult grandson to buy a house for this family. In March of 2014, after Bunny Mellon's death at the age of 103, her grandson inherited over $5 million in the first installment. The second installment would be paid 2 years later when he turned 40, and that was another $5 million. But the key are these 2 dates in the center of the timeline. June 2014 through September 2015. And we'll look at that in detail because that includes the first affair, negotiating a postnuptial agreement, and determining the amount of the adultery penalty provision. In 2016, while they're still married, the husband inherits the second installment from Bunny Mellon's estate. That's another $5 million. In February of 2017, the wife is appointed as the social secretary for the White House. And in March of 2017, the husband's father died at the age of 80. His health had been poor in his late 70s. And like Bunny Mellon, he was an ultra net worth individual. The son anticipated inheriting approximately $12 million at the time the postnuptial agreement was negotiated and signed. But according to briefs filed in the case, he actually inherited $26 million from his father. But a caveat to that is a lot of it was not liquid, including real estate that was not income-earning real estate. Husband's adultery discovered by the wife in 2014, and an extensive reconciliation process, including negotiating and signing a postnuptial agreement. The postnuptial agreement was negotiated over months. Husband had 2 lawyers, wife had 2 lawyers. Husband had an estate planning attorney and a family law attorney. Wife had an estate planning attorney and a family law attorney. In early 2015, the wife demands this postnuptial agreement. Months of negotiations, and the original penalty proposed for any future adultery was $5 million. One material fact that is emphasized by all of the courts that looked at it is that $5 million adultery provision was increased by $2 million at the suggestion of the husband. The husband's lawyer, in an email to the wife, referred to the $7 million adultery provision or penalty as the bad boy clause. There is no comparable provision for the wife. There is no bad girl clause. It's one-sided regarding adultery and other conduct detrimental to the marriage. Some key terms in the postnuptial agreement. First is the property division. The husband agreed to fund a joint marital account using a significant portion of his inheritance from Bunny Mellon. Now remember, he inherited $5 million in 2014. He expects another $5 million 2 years later. As part of this postnuptial provision, the husband agrees to deposit money from his separate account, the inheritance that would be separate property if they divorced. The husband transmutes his inheritance from Bunny Mellon. Transmutation is a legal concept where separate property becomes marital property. It can happen intentionally, or it can happen by commingling separate assets with marital assets or paying marital expenses. In the Lloyd case, the husband agreed as part of a postnuptial agreement to fund a joint marital account with his then wife, funding it from his first installment of the Bunny Mellon inheritance. So a portion of that first $5 million funds a joint account. And they don't just hold this joint account jointly. It's titled tenants by the entirety. That does not exist in community property states. Maryland is an equitable distribution state. Many equitable distribution states, like Maryland, have tenants by the entirety. In tenancy by the entirety, each spouse has an undivided interest in the whole account. Now, how is that possible? How can 2 individuals have an undivided interest in one account, one asset? And that's the legal fiction of marriage, where they are a single marital unit. It also has inheritance consequences. Once an account or real property is titled as tenants by the entirety, the surviving spouse automatically inherits all of it. After signing an agreement like this, trying to create an estate plan or a trust has no effect on tenants by the entirety. So once the husband funded some of his inheritance from Bunny Mellon into a joint account with his wife as tenants by the entirety, he could no longer change who inherited it from him. But there's more. As part of this postnuptial agreement, the wife would receive 50% of that account. They called it Schedule B assets. And not just the Bunny Mellon inheritance was in it, but we know around $10 million of the Bunny Mellon inheritance ended up in this joint account as part of the postnuptial agreement. If they divorced, According to the postnuptial agreement, the wife would get her 50% share of Schedule B assets, meaning 50% of most of the Bunny Mellon inheritance. As part of the $7 million adultery penalty, the wife would not only receive 50% of the Schedule B assets, those joint assets, she would also receive up to $7 million from the husband's 50% share of the Schedule B marital assets. Wait a minute. So that means she gets 50% in divorce, and she could get possibly another 50%. $7 million was the ceiling. She couldn't receive more than $7 million, but she might receive less if his 50% share did not add up to or did not exceed $7 million. If it was only $5 million at the time of a divorce, after she proved his second adultery by preponderance of the evidence, she would not only receive her 50% share, she would receive everything of his share if it didn't equal $7 million. If it equaled more than $7 million, she would get $7 million and he would keep the rest. This is pretty draconian, and you're going to see those facts play into the husband's arguments at the divorce trial, at the intermediate appellate level, and at the Supreme Court level in the state of Maryland. Something else that's key throughout all three courts' review of this is that the husband signed the postnuptial agreement featuring the $7 million adultery provision against legal advice. Lawyers call this the stupid clause. Signing something this significant, this financially detrimental to only one spouse against legal advice is a bad idea. You already know that. Well, he certainly found that out because of all the litigation after a second affair was proven by the wife by a preponderance of the evidence. Now, I know you can't read this slide. I can't even read this slide, but it's a reminder for all of us to review the case itself. In the show notes for this episode, we have the citation and the case itself. Have a look at it. It's really an excellent case for non-lawyers to also read because the Maryland Supreme Court really laid it out in a well-organized and understandable fashion. It's an excellent teaching case to see what facts are relevant, what facts are material, what facts are outcome determinative. There's another section of the case that disregards some arguments, basically concluding some law was inapplicable to this type of an agreement, and then separately holds what law is applicable before applying to the material facts to determine the result. So preview, the husband loses at the trial level, he loses at the intermediate appellate level, but at the Supreme Court level in the state of Maryland, the husband wins on a couple of things. And he argues that the court should stop while he's ahead. So we're going to see whether the court stopped and how it all turned out. But in this postnuptial agreement, the wife is going to receive up to $7 million if the husband has an affair and the wife proves the infidelity by a preponderance of the evidence. That's a legal standard that simply means more likely than not, but she has the burden of proof. In this case, that was never at issue. The husband did not deny a second affair, which precipitated the divorce proceedings and triggered the possible enforcement of the $7 million adultery provision. Why did the husband agree to this? Why did the husband propose an additional $2 million, taking it from $5 million to $7 million? According to one of his lawyers, he wanted to make it clear that this infidelity would not occur again. There's a lot of contrition here in the facts and in the agreement itself. And the husband agreed to 5 steps in addition to the $7 million adultery provision to support the reconciliation. He agreed to give his then-wife the passwords to his financial accounts and his email accounts. He used a portion of his inheritance from Bunny Mellon, a little over $10 million, totally inherited, but a significant portion of that funded those Schedule B assets to support the $7 million penalty provision. He converted to his wife's religion, so he converted to Catholicism. He sold the car used with his affair partner, and he had a vasectomy. So those are a lot of events that occurred to reconcile. Unfortunately, it doesn't last. In the second timeline, February of 2017, the wife is appointed as the social secretary for the White House. March of 2017, the husband's father, another ultra-net worth individual, dies, and the husband, who in 2015 expected to inherit from his father approximately $12 million, actually inherits closer to $26 million. However, some of those assets are illiquid, real estate, and some of that real estate is not income producing. The husband's inheritance from his father is not subject to the $7 million adultery provision, but the Bunny Mellon inheritance is. In October of 2018, the husband begins a second affair. In April of 2019, the wife discovered the husband's second affair, and by mid-month she files for legal separation. 6 months later, in October of 2019, the wife filed for divorce on the grounds of adultery. At that time, Maryland was a fault jurisdiction. Adultery was an example of filing a fault-based divorce. Also in Maryland, fault affects monetary division of marital assets, marital debts, and even the calculation of alimony. Fault at this time was a big deal in Maryland, but put a post-it on this because the regime in Maryland changes while this case is pending on appeal before the Maryland Supreme Court. In August of 2023, the Maryland Supreme Court issues its decision. So between October of 2019 and August of 2023, 3 different courts rule on this case: the trial court within the divorce itself, the intermediate appellate court, and then the Maryland Supreme Court. In October of 2023, Maryland changes from a fault-based divorce jurisdiction to a no-fault divorce jurisdiction, and that's going to have an effect on the precedential level of what the Maryland Supreme Court decided, because this marriage and this postnuptial agreement and this divorce all occurred while Maryland was a fault jurisdiction. $10 million. I know the slide says more than $10 million, but we're just going to go with $10 million. The husband inherited from Bunny Mellon, his paternal grandmother, over $10 million in 2 installments. He has already received the first installment at the time of the first affair being uncovered, at the time of the reconciliation, at the time of the negotiation of the postnuptial agreement. And the husband agrees to transmute the first installment. Well, the whole installment was $5 million. The record doesn't say how much he put into the joint marital account, those Schedule B assets. But let's assume he puts in $5 million. 2 years later, when the husband turns 40, he receives the second installment from the Bunny Mellon estate. So now he's inherited over $10 million. And according to the postnuptial agreement, he has to put that money, the second installment, into the Schedule B assets. Now, the numbers in the lower right are from the husband's attorney's briefs during the appeal. If husband and wife divorced under the postnuptial agreement with no adultery, the wife would receive half of those Schedule B marital assets, and the husband would receive half. So let's assume $5 million to the wife and $5 million to the husband. But as the husband's lawyers point out under their financial unconscionability argument, based on his finances and the Schedule B assets as of 2015, that's the only relevant time. Whether the postnuptial agreement is financially unconscionable, it's not at the time the divorce is filed. It's not the time of the divorce trial. It's at the time the postnuptial is signed. At the time the postnuptial is signed, based on the assets, he hasn't inherited the second installment from Bunny Mellon yet. His father is still alive. He hasn't inherited from that estate yet. According to the husband's lawyer's briefs, if they had divorced in 2015, the wife would have received $15 million, and the husband's number was a negative $1.2 million. Wait, what? This is what the postnuptial agreement plain language states, that the wife receives 50% of those Schedule B marital assets. If there's $10 million in it, there's actually more, but if there's $10 million in it, the wife receives $5 million. And then, according to the $7 million adultery provision, the wife receives up to $7 million out of his 50% share, and according to the husband's lawyer's math, to support financial unconscionability, to overturn the postnuptial and make it unenforceable, the wife was receiving $15 million. Now remember, this math existed in 2015, and the husband signed that postnuptial against legal advice. But maybe showing someone numbers like this would help reinforce the against legal advice. Maybe the against financial advice, boosting the against legal advice, would help clients protect their inherited wealth. We have 5 legal arguments from the husband at the trial court, intermediate appellate level, and the Supreme Court level. And the Maryland Supreme Court addresses all of them. The first argument, lack of consideration. The husband agreed to a $7 million adultery provision, and he funded significantly those Schedule B marital assets. He agreed to put in the second installment, over $5 million inherited from Bunny Mellon that he hadn't yet received in 2015, but also a portion of the first installment. So just assuming he's put in $10 million, the wife didn't put in anything according to the postnuptial agreement that appears in the Maryland Supreme Court decision in the Lloyd case. So lack of consideration. What value did the wife bring? Because a contract to be enforceable has to have three things: an offer, acceptance for consideration. Consideration is a legal term, something of value. Something of value can be money, obviously, but also could be behavior, doing something or not doing something because of the agreement. Another main argument for the husband on appeal was unconscionability, the gross financial disparity that we just looked at. Undue influence. This one I'm not going to spend a lot of time on because we have in the show notes the citation to the case and a link to the public version of the Maryland Supreme Court decision in the Lloyd case. You should read it for yourself. But one caveat to think about is when one spouse is the heir of two ultra net worth individuals who's already received significant inheritance, has a reasonable expectation of additional inheritance, it's difficult for that spouse's lawyers to write a persuasive argument for undue influence. So you're going to see the limits and possibly the loss of credibility. Strategically, in any litigation at the trial level, you're setting the record for the appeal, but strategically on the appeal, was this argument worth it? How much did this particular argument detract from the other? Husband and his lawyers argued that this $7 million adultery penalty is against the public policy of Maryland, that it's an illegal punishment. And then impossibility. The relevant time frame to evaluate the fiscal feasibility of the $7 million alimony penalty provision is 2015 when the postnuptial agreement was signed. And at that time, he'd only received the first installment from Bunny Mellon. He had not received the second $5 million because that was 2 years later. His father was alive. He hadn't received an inheritance from his father. And according to his lawyer's math, he was at a negative $1.2 million with the wife under the postnuptial as it was signed, scheduled to receive $15 million if there was any additional adultery. Some of the wife's legal arguments included that this is not illegal liquidated damages. This isn't even liquidated damages. It was a reframe that this is a lump sum provision dividing marital assets. Additionally, the wife and her lawyers admitted during the intermediate appellate oral argument that this was a penalty, but that the penalty is still enforceable in Maryland. So what did the trial court hold and what did the intermediate appellate court hold? It depends on who you ask what to even call this $7 million clause. The husband and his lawyers argued it was an illegal liquidated damages clause. And the husband wins on this issue before the Supreme Court of Maryland. If it's a liquidated damages provision, liquidated damages have to bear some proportionality to compensatory damages, actual damages. Well, is adultery worth $7 million? How do you even quantify that? That was the argument by the husband and his lawyers, that this is a liquidated damages provision, just $7 million if the wife proves by preponderance of the evidence that there's a second affair, and that there's no relationship to actual damages suffered by the wife, so it's not enforceable, is the argument. Maryland Supreme Court agreed with him and held that yes, if this were a civil contract and not a marital agreement, and if it were a liquidated damages provision, it is unenforceable because any damage from the adultery is not balanced with $7 million. It's completely out of whack, not enforceable. And the husband and his lawyers argued, hey, Maryland Supreme Court, stop right there. Well, the Maryland Supreme Court did not stop right there. He still has some more chances to possibly prevail. He lost at the trial level. He lost at the intermediate appellate level. We'll see what the Maryland Supreme Court did with the rest of it. Now, the penalty. His own lawyers referred to this as the bad boy clause. There was no bad girl clause. There was no anti-adultery clause in the postnuptial agreement. Under the statutes in Maryland at the time of the postnuptial and at the time the wife filed for divorce, if the wife had committed adultery, which she did not, hypothetical now, the husband could have filed for divorce on the grounds of adultery of the wife. That's equal opportunity, but the postnuptial was one-sided. He was the only one with the bad boy clause, this penalty, and the wife and her lawyers admitted at the oral argument of the intermediate appellate court that this was a penalty, but it was still enforceable. And then finally, the reframe before the Maryland Supreme Court, which the husband's lawyers pointed out, hey, you can't reframe this now, you needed to litigate this earlier, that this is merely a lump sum provision dividing marital assets. So which of these did the Maryland Supreme Court pick? We're going to find out. The trial court. As part of the divorce trial court heard testimony from the husband and everyone relevant about the bad boy clause, about the $7 million adultery provision. And the trial court disregarded the husband's testimony because his testimony looked nothing like the contrition and the remorse and the let's stay married person who negotiated and signed the postnuptial. The divorce trial court emphasized the against legal advice statement, that the husband signed the postnuptial against legal advice. The divorce trial court held that this agreement for the husband, from his perspective, was improvident but not unenforceable. Here's a quick sidebar. Divorce courts at the trial level are not there to save anyone from their own bad deal. You're actually allowed to make a bad deal. But when you try to undo it later, buyer's remorse after mediation, buyer's remorse after the divorce trial. When you try to undo it later, it oftentimes doesn't work. Another aspect of the divorce trial court's ruling is that the husband assumed the risk. Two in particular. One, that he might not inherit anything from his father or might not inherit the amount he anticipated, which was needed to balance out transmuting chunk of the $10 million from Bunny Mellon into a marital asset. Second, that he not engage in infidelity. That was another risk the husband assumed. And then the final piece of this decision, the divorce trial court decision that I'll mention, is that the divorce judgment incorporated but did not merge the postnuptial agreement, which means the postnuptial agreement remained a contract. When any marital agreement is incorporated and merged, which is not what happened here, it is interpreted as a contract, but it's enforced solely as a court order. There is no more contractual enforcement. When it's incorporated but not merged, you have the opportunity in some states to enforce the court order aspect and to separately enforce the contract. That's what we're working with here for appeal. Now, what did the intermediate appellate court do? The main outcome of the intermediate appellate court is that, this bad boy clause, this $7 million adultery provision, it's a penalty and it's enforceable in Maryland. The intermediate appellate court in Maryland relied on the McGinn case, and that's the decision that really looks like dicta. Dicta is when a court at any level makes a statement that isn't necessary to its actual holding. For example, if it's a hypothetical statement, hypothetical facts are not part of a holding. So that's how you can end up with dicta. And in this instance, the wife's lawyers are relying on McGinn, and the husband's lawyers are saying, you can't rely on it. It isn't precedential for this aspect of it. Well, the intermediate appellate court did rely on McGinn, and that the lump sum provision finally was not unconscionable because the husband controlled the trigger for it. The results in the Maryland Supreme Court. Before we look at what the Maryland Supreme Court did, we have to talk about the appellate standard of review. A standard of review on appeal is sometimes outcome determinative. Here, the standard of review for all the issues before the Maryland Supreme Court was de novo. De novo means whichever appellate court is looking at a particular issue under this standard, they step into the shoes of the lower courts. They can make their own rulings. They are limited by the record. So the record is set at the trial level, and then whatever is properly included in the appellate record, and that's it. Anything that wasn't argued at the trial level is usually waived for the rest of any appeals, and any fact or aspect of the record that is not incorporated into the appellate record is invisible. But the Supreme Court and any appellate court can affirm on any grounds supported by the record, even if it's not what any of the lower courts relied on. So they can disagree with the lower court and still affirm. Most appeals are affirmed. There's an advantage of winning at the trial level and, of course, winning at the intermediate appellate level. Affirming is much more likely. This de novo review, we have the Maryland Supreme Court acting as if it's the trial court. So it looks at what the trial court held, it looks at what the intermediate appellate court held, and in some instances, it makes its own decision, and its ultimate ruling is based on the record, but not the law of the trial court and the intermediate appellate court. So let's see how the husband did. The wife's argument is summarized by the Maryland Supreme Court in its ruling. The wife argued that this was not a penalty, but a lump sum provision transferring property from the marital estate to one spouse, here the wife, based on conduct, husband's second affair. The wife and her lawyers emphasized that Maryland, at the time of this marriage, at the time of the postnuptial, at the time the wife filed for divorce, was a fault jurisdiction, and that she filed for divorce on the grounds of adultery. States that have rejected this type of adultery provision, like California and Iowa, are no-fault states. Her lawyers distinguished those cases because at this time, Maryland was a fault state and not a no-fault jurisdiction. The wife argued that the husband misread McGeehan, attempting to minimize it, but at this point in time, McGeehan is dicta, so that's one on the husband's side. And then finally, that the Maryland court system should not restrict the freedom of married spouses to decide how their assets are going to be divided. It's like the freedom to disinherit any heirs you may have. Married spouses, before they get married, can sign a prenuptial. While they're married, can sign a postnuptial, and can also negotiate at mediation a property settlement agreement, which in some states is a marital settlement agreement. The husband's reply, so he's reacting to what she argued, pointing out that you can't change what you admitted at the lower court levels. You agreed, wife and your lawyers, that this was a penalty. Now you're saying it's merely a lump sum redivision of assets. This penalty concession and the reframing, the husband's lawyers are arguing, should not work before the Maryland Supreme Court. But the math that we've already looked at, that the husband's obligation exceeded the marital estate in 2015. That's the relevant year when the postnuptial was signed. Not later when he inherited the second installment from the Bunny Mellon estate, not later when he inherited from his father's estate, even though those assets were not liquidated, did not get deposited into the Schedule B marital assets. And then finally, that this was massively lopsided. Only his behavior was constrained. Only he funded from separate assets the Schedule B marital assets. So what did the Maryland Supreme Court decide? Well, first, the Maryland Supreme Court agreed with the husband. The Maryland Supreme Court agreed with the husband that if this was a liquidated damages provision in a civil contract, it is unenforceable, because it was so disproportionate from any damage actually suffered. But then the Maryland Supreme Court held that marital agreements are interpreted as contracts under the canons of construction for contracts, but they also have some separate provisions, separate interpretations, separate tools for enforcement that are different from civil contracts. And ultimately, the Maryland Supreme Court rejected liquidated damages entirely, holding that it's not applicable to marital agreements. Second, the Maryland Supreme Court held this is not a penalty, that if it were a penalty, it would be unenforceable, but that it's not a penalty. Instead, the Maryland Supreme Court held this is a lump sum provision merely directing the division of assets based on contingent conduct, here, husband's infidelity. The Maryland Supreme Court held that this postnuptial agreement was valid and enforceable. It also held that adultery-based lump sum provisions that transfer assets between spouses based on that conduct is enforceable. The Maryland Supreme Court rejected liquidated damages and that aspect of civil contracts and confirmed what is applicable in marital agreements. The Maryland Supreme Court also emphasized that the parties were represented by counsel, that this agreement complied with public policy in Maryland because Maryland is against adultery. At the time the wife filed for divorce under grounds of adultery, adultery was against the public policy of Maryland, and it still is, even though between the Maryland Supreme Court decision in August of 2023 and the October 2023 change in Maryland from a fault jurisdiction to a no-fault jurisdiction, there are still several ways for adultery and other fault to impact the asset division and even the calculation of alimony. And then finally, this is another big one, the limitations on recovery. The Maryland Supreme Court was strongly influenced by those Schedule B assets, that the $7 million amount would be funded only from the husband's 50% share of what became marital assets, even though the husband transmuted up to $10 million of his inheritance from Bunny Mellon, which would have been a separate asset if he had kept it separate. But in that postnuptial, he agreed to fund a portion of those inheritance installments into the marital assets held as tenants by the entirety. Because the $7 million lump sum provision was funded solely out of marital assets and solely out of the husband's 50% share of those marital assets. For example, hypothetical, if husband had kept the Bunny Mellon inheritance $10 million in an individual account, never transmuted it, it's unlikely that the Maryland Supreme Court would have enforced this postnuptial, that the $7 million bad boy clause would be funded by separate assets. You'll see when you read the decision that the court is influenced by the source of funding from marital assets. All right, so what happens with the McGeehan case? I want to read the quote that was dicta, and then we'll look at what the Maryland Supreme Court did with it. Many postnuptial agreements attempt to use financial rewards and penalties to create incentives during a marriage that constrain the behavior of both spouses. That's the quote from McGeehan. The Maryland Supreme Court confirmed that's dicta. That was not necessary to the holding, did not have precedential value, but there's a concept called dicta now holding, and the Maryland Supreme Court converts that dicta into a holding, into binding precedent. Because, and this is what the Maryland Supreme Court wrote, this dicta accurately described the law in Maryland. So now, what the lawyers were dealing with, they did the best they could. It was not until this Lloyd case where the Maryland Supreme Court stepped in, confirming that this clause from McGeehan is dicta as holding. The other case I mentioned, Lloyd, is from Pennsylvania, and the gist of this one, also relied heavily on by the Maryland Supreme Court, is that spouses can transfer property for any reason, so long as that reason is not illegal. And adultery in Maryland, being a grounds for divorce, comports with Maryland's public policy against adultery. So here's the quote from Lloyd. There should be no reason why a transfer would be invalid if conditioned on the occurrence of a specified type of conduct, because spouses are permitted to transfer assets to each other for any reason. If you think about it, that just makes sense. But there's one more aspect of the Maryland Supreme Court decision in the Lloyd case that gives us some pause. And some commentators have already pointed this out. The Maryland Supreme Court relies on cases from other jurisdictions that are fault jurisdictions, which Maryland itself was up until October of 2023. The Lloyd case comes out in August of 2023 with Maryland as a fault jurisdiction. Well, now that Maryland has converted to a no fault, does that mean the Lloyd case is gutted? So here's what the Maryland Supreme Court agreed with the husband on. We agree with husband that the lump sum provision would constitute an unenforceable penalty had the agreement been a traditional contract of law rather than a marital contract. And the husband argued this, and the court should stop. The court did not stop and takes us through marital agreements as contracts. So they're contractual in nature. Courts interpret them under the canons of contract construction, and they are enforceable unless found to be unconscionable, fraudulent, or violate public policy. Those were the husband's main arguments. And subject to modification, not unilaterally, not alone, but through agreement of the parties. Nevertheless, the Maryland Supreme Court in the Lloyd case rejected the liquidated damages framework and is very specific that marital agreements are not subject to liquidated damages, and anything that would be unenforceable in a civil contract as disproportionate liquidated damages is not necessarily unenforceable because it's a marital contract. The main reason is there's no compensatory damages in a divorce case. It kind of feels like there is, but there isn't, even in fault jurisdictions or jurisdictions where fault can affect the division of assets, the calculation of alimony. In some states, if the dependent spouse is the one who is found to have committed adultery, they may be denied alimony entirely. And the Maryland Supreme Court also held and agreed with the wife's lawyers that using the liquidated damages framework from civil contracts would limit spousal autonomy to decide what to do with their assets through prenuptial, postnuptial, and marital settlement agreements as part of a divorce. So ultimately, this $7 million provision was a lump sum interspousal distribution of marital assets contingent upon the husband's infidelity. The unconscionability argument has two parts: procedural unconscionability and substantive unconscionability. In the Lloyd case, the Maryland Supreme Court held it was procedurally not unconscionable and substantively not unconscionable, mainly because procedurally they both had lawyers. They each had two lawyers when they negotiated the postnuptial. It was a voluntary negotiation. The husband was demonstrating his recommitment to the marriage. The husband himself initiated the increase in the $7 million lump sum provision from $5 million to $7 million. And then the financial capacity argument. The Maryland Supreme Court held that we look at 2015, but the second adultery has not happened yet, so that the wife isn't entitled to the $7 million yet. And if you do the math that way, it is not disproportionate. She's not getting $15 million. They're each dividing approximately $10 million, and they both get $5 million. And that is not unconscionable. But we do have one more thing to cover in this case, and that's the change for the state of Maryland from a fault jurisdiction to a no-fault jurisdiction. How does that affect the Lloyd decision? Well, the Lloyd decision was pending before the Maryland Supreme Court at two key times. First, when Maryland's governor signed the bill that became the statute that converted Maryland from a fault jurisdiction to a no-fault jurisdiction. That was signed in May of 2023. That provision didn't take effect until October of 2023, and the Lloyd decision comes out in August, right before Maryland changes from fault to no fault. I looked at the decision, looking for what the Maryland Supreme Court did to preempt questioning of of the precedential value of the Lloyd decision. It's binding on this marriage, but do people have to relitigate these issues because of this change and because of the court's reliance on fault jurisdictions to allow lump sum transfer of assets, where jurisdictions like California have rejected that exact provision because they're no fault? And I found footnote 17, which means you have to read pretty thoroughly to find it. In footnote 17, the Maryland Supreme Court confirms Maryland still looks at fault. Even under the new no-fault jurisdiction, when you file for divorce in Maryland, you can choose irreconcilable differences, and in footnote 17, they reinforce that you can list the reasons for your irreconcilable differences as a fault-based instance like adultery. So it's still even relevant to filing for divorce in addition to impacting the division of assets, because in an equitable distribution state like Maryland, it has to be fair, but division does not have to be equal. Risk allocation. This was another key piece of the Maryland Supreme Court decision, that the husband controlled the risk. He was the trigger, or he controlled the triggers. One trigger is to not commit adultery. He controlled that. Another, which the Maryland Supreme Court points out, is the husband, before the second affair, the husband was aware of the $7 million provision prohibiting adultery, triggering a lump sum transfer of up to $7 million to the wife from marital assets if she proved by a preponderance of the evidence second adultery. The postnuptial also lists other conduct, and I haven't talked about it because the Maryland Supreme Court emphasized that it was only addressing the actual facts, actual adultery that the wife was able to prove by a preponderance of the evidence, and not these lesser instances of lack of commitment to the marriage. And it's unclear whether any of these courts would have enforced the $7 million provision based on these lesser. It's a pretty detailed list of what else he couldn't do. He couldn't contact the previous affair partner. So what if he had just contacted that person? Would that have triggered the $7 million? The Maryland Supreme Court held, we don't have to decide that because it was proven by preponderance of the evidence that the second affair happened. But then the Maryland Supreme Court pointed out, you know what he could have done? He could have filed for legal separation or filed for divorce before having a second affair. And this $7 million provision would have been nullified. It's only because the affair happens during the marriage that the postnuptial kicks in concerning the $7 million adultery lump sum asset division. The husband is the one who added the $2 million. His testimony at the trial level tried to address that issue. It was unsuccessful. The trial court was not persuaded by the reframing. The husband's retained assets in 2015 included a $12 million expected inheritance from his father. Now, he received $26 million when his father died in 2017, but the expectation was part of the husband's reasoning to sign this postnuptial. And then the main kicker, that the $7 million was only paid from husband's share of marital assets, even though the husband transmuted separate inheritance assets to fund most of it. It became marital, and up to $7 million only came out of his 50% share of those Schedule B marital assets. What legal propositions does this case stand for? What can we cite it for? Postnuptial agreements with a lump sum provision conditioned on conduct like adultery are enforceable if, and you have to meet the criteria that the Maryland Supreme Court spells out, that the liquidated damages legal framework is inapplicable to marital agreements, and that does not have to be relitigated. That is the law in Maryland and probably helpful for other jurisdictions. That penalties in postnuptial agreements are different from civil penalties, civil contract penalties. That's the discussion in the Lloyd case about how marital contracts, yes, they are interpreted as contracts, but they are not civil contracts because it is a marital. There are goals for marriage and goals for self-determination of who gets what asset when the marriage is dissolved. Spouses may freely transfer assets. This is that Pennsylvania case that Maryland relied on. Spouses may freely transfer assets for any reason. They just can't do it for an illegal reason. And adultery, as the trigger, is not an illegal reason. Payment limited to the breaching spouse's marital share of assets is enforceable. And then one issue that we haven't discussed until this point, the husband argued that this was lopsided. He was the only one who provided value. The wife provided no value. Remember, she didn't fund the Schedule B marital assets, but Maryland Supreme Court held that the wife's forbearance, she was going to file for divorce after the first affair without this postnuptial that they negotiated and ultimately signed, and that was sufficient consideration. This is an issue because prenuptial agreements, the consideration is we don't get married if we don't sign this prenuptial. The consideration is actually getting married. But in a postnuptial, you're already married. So what's the consideration? Here, it was the wife had grounds to file for fault-based divorce based on his adultery, and she didn't. And in order to file for fault again, he needed to have a second affair, which she took the risk on, so to speak. Our takeaways for wealth protection. Hopefully you've been seeing them yourselves, but let's together go over some of the wealth protection takeaways from this case. Documentation is critical. Document legal advice. Document an against legal advice decision. Financial advice and document against financial advice decision. Another takeaway is just showing that big number, that $10 million, that without a second adultery, he would have kept $5 million and she would have gotten $5 million. Without the postnuptial, he would have kept all $10 million and she was getting $15 million as of 2015 and he would be at negative $1.2 million. For some people in the remorse phase of whatever reconciliation they're trying to foster, maybe those numbers would break through. The lawyers and his financial advisor certainly tried. For you, you can use this case to help a client who's in a similar situation, considering going against legal advice, considering going against financial advice. And then finally, the proportionality of the penalties, because these penalties were completely unproportional, and it's not impossible to make those penalties proportional. High net worth client protection, postnuptial agreements are enforceable because they're given heightened scrutiny. In this instance, it was enforced. Independent legal counsel is essential. It is not the best idea to transmute inherited wealth if you ultimately end up getting divorced. Sometimes transmutation occurs unintentionally, commingling of assets, using an inheritance to fund the marital lifestyle. Here, in the Lloyd case, it was not only intentional, it was contractually agreed that it would happen under the postnuptial agreement, and then document the client's decision-making process. Critical takeaways for wealth professionals. Postnuptial agreements with substantial contingent penalties are enforceable if you're in a jurisdiction where fault is a factor. The opposite may be true in a state like California. Those are unenforceable because of a no-fault jurisdiction. But make sure you and your client get the legal advice you need based on your state. Otherwise, if the penalty is proportionate, that may still be enforceable. Or simply asset transfer for any reason. If we get divorced, here's how we're going to divide the assets. That is enforceable, because as long as you have no reason or a legal reason, you can divide the assets how you want, even in a postnuptial. Sophisticated clients are far less likely to succeed on an unconscionability argument. You should read the case yourself and decide how much credibility was lost by trying to even make that argument for the husband, because factually, he was the heir to two ultra net worth individuals. He was anticipating a separate inheritance that ultimately didn't get funded in the marital estate. Unconscionability was unlikely, and the arguments were the best available, but they really are not the best. Not that the lawyers did anything wrong. That's just the facts were not in his favor on unconscionability. And that inherited wealth has unique marital vulnerabilities, and this is just another actually litigated example of that may help your clients see more clearly what the risks are from certain decisions. Thank you for joining us. Stay tuned for a preview of our next episode.
When a widow receives over $3 million in the first year after her husband's death, with monthly checks averaging $13,000 and a $5 million Q-tip trust, she discovers a devastating catch. She doesn't control most of it. Every request requiring trustee approval, the same lawyer and law firm that drafted the premarital agreement and her late husband's estate plan, gives them absolute discretion. So she fights back for financial independence. But the estate plan has one of the most powerful weapons in trust law: 3 no-contest clauses. Challenge the trusts, and you lose everything. This 2-part deep dive analyzes the Laysighter case, where secret distribution directives, legal malpractice litigation against trustee, and a $1.4 million clawback risk created a high-stakes legal battle intersecting settler intent, forfeiture, and professional conflict of interest. Join us for No Contest Trust Trap. Widow Risks, 1.4 Mayor Clawback for Control. Episodes 103 and 104 of the Wealth Litigated podcast. Delivering all the drama of true crime without the blood.
This is Wealth Litigated, where the real courtroom battles we analyze today are your roadmap to stronger asset protection and better wealth outcomes. Follow us on your favorite podcast platform or subscribe on YouTube so you never miss a weekly episode. Questions or cases? Visit wealthlitigated.com/questions. This show is for informational and educational purposes only and does not constitute legal, tax, or financial advice. No attorney-client relationship is formed. Consult a qualified professional for advice specific to your situation and jurisdiction. Wealth Litigated is now adjourned.